One of the worst hands in life that you can be dealt is to be born without parents. You could be adopted. You could be in an orphanage, or your parents could have passed away. Whatever the circumstances, if you are without your parents, that is quite a burden. And if you get adopted, the question today is, what happens if your estate plan, or if your new parents' estate plan, how does it affect you because you're adopted versus other children who are just born to those parents? So I wanted to talk about adopted children, but if you have any other questions today, you can email me directly or go to my website, www.legionlawpllc.com, and schedule a free consultation on the Contact Us page. So adopted children in Texas really aren't treated any different. They get to receive the same inheritance if the parents die without a will. The same default laws apply to adopted children as they would to naturally born children. I don't know, blood children. I guess blood children is a really strange term, but I guess that's the appropriate phrase. Either way, all the children are treated the exact same, regardless of the circumstance. So, if there's 4 children, one of them's adopted, then 25% for all the children in the circumstance where a child is supposed to receive something. If there's a will, on the other hand, we do whatever the will says. So if the will excludes the adopted child for whatever reason, the adopted child is going to be excluded, but that doesn't have anything to do with them being adopted. That just has something to do with the parent excluding them no matter what. So again, going back to the 4 children, if the 4th child's adopted, a will could say child number 2 and child number 3 get something, but 1 and 4 get nothing. And that is completely valid as well. But again, that has nothing to do with being adopted because child number 1 was excluded as well. So I say all of that, but there's actually a big asterisk to this because you have to actually have formal adoption. There's a process by which you have to go in front of a judge. You go through the adoption process. It's a whole song and dance, apparently very expensive. I've never had to adopt a child myself, but you do have to get a judge to sign off and say, yes, you are the new parents of this child. Because if you don't, and you're just simply taking care of a child and you treat them like your own child, and informal adoption, if you will, if you are taking care of your sister's kids and she just doesn't want to be a parent or whatever, that's not actually adoption. You have to get the formal process done and get it signed off before you consider that child like a part of the family by the estate planning standard. So if you have an informal child who's, again, you're just taking care of them, you treat them the exact same way as every other child, but you never do that formal process, then that child will be considered just a resident, like a roommate of your children. They're not actually adopted siblings or anything like that. So be sure to go through that process. Be sure to talk to an attorney to make sure that you have everything in order so that an adopted child is treated the same as a child who's not adopted but born to the family. So with that, if you have any questions on it, be more than happy to chat. You can email me directly, Derek, D-E-R-E-K, at legionlawpllc.com. Or you can find me at my website, www.legionlawpllc.com. Go to the Contact Us page and schedule a free consultation over the phone to talk about what happens when certain children are adopted one way or the other. Or anything else. If you want to just see how everything's going, and I'd be able to tell you how my day is. So with that, thank you so much for watching and have a great day.